The second case on the docket for Wednesday, March 30th, 2022 is appeal number 122252, State of Kansas versus Carrody M. Buchhorn, Douglas County. Briefs both sides.
Counsel, would you please approach the lectern and enter your appearances?
May it please the court, the state appears by Deputy Solicitor General Chris Elsliger.
Good morning, Your Honors. May it please the court. My name is Bill Skepnick, and together with my co-counsel Quentin Templeton and Stephen Skepnick, we represent Mrs. Buchhorn, who is also here with her family. That's the crowd.
All right, thank you. Elsliger, whenever you are settled and ready, you may begin your argument.
It please the court. I am Chris Elsliger of the Attorney General's office, appearing on behalf of the state. And just by way of explanation, after a review was granted in this case, Douglas County Attorney's office asked our office to take over the case for various reasons. So that's why I'm here, and to use my well-used baseball analogy, I again feel like a bit like a relief pitcher coming into the ninth inning. Seems to be the last 4 or 5 times I've been in front of this court, it's been that way. But you'd think I'd start getting good at it. So my first order of business would be, I would like to ask for 4 minutes of rebuttal time.
4 is granted.
And this case involves a defendant who was convicted of second-degree reckless murder in the death of an infant, OO, who was in her care at the time. She worked in a home daycare center where the baby had been dropped off. Longtime coroner, Dr. Eric Mitchell, concluded that the baby died, suffered an almost instant death after suffering a head injury. The defense hired an expert of their own, another forensic pathologist, to counter Dr. Mitchell. This was Dr. Wigren, who believed or concluded that the injury was much older, and so the infant could not have died instantly after suffering this injury, and that therefore the death could not have happened while the infant was in the care of the defendant. The defendant was convicted. Post-trial, she hired new attorneys who then filed a motion for new trial and challenged the effectiveness of her prior counsel, arguing that prior counsel had failed to properly investigate Dr. Mitchell's theory on the cause of death and had failed to properly present expert testimony to counter it. The district court rejected that argument, found that counsel was effective, but on appeal, the Court of Appeals held that counsel was ineffective in their presentation of the case. So that brings us here. The state filed a petition for review, and opposing counsel filed a cross petition. Both were granted. I think at the beginning, although I know the court is well aware of the standard, but it bears repeating to kind of get us all grounded again on what the standard for ineffective assistance is. It comes from Strickland v. Washington, U.S. Supreme Court case. And the standard for performance is objective reasonableness. Objective reasonableness. And it's not about what another attorney would have done. It's not about what the best attorneys would have done. It's not an exercise in grading counsel's work. Counsel's performance is not expected to be flawless, as many courts have said. In fact, the U.S. Supreme Court has said that. The other thing that Strickland tells us, we have to avoid the distorting effects of hindsight. In hindsight, you can always look back on something and see how something different could have been done, something better could have been done, maybe another stone could have been overturned, but that's in hindsight. Have to view it from the perspective of counsel's point of view at the time in the context that they were dealing. And significantly, it's not about what counsel could have done. The review is based on what counsel did do, what they actually did, and whether those actions were objectively reasonable when viewed from their perspective at the time. So I think the Court of Appeals erred in 3 fundamental ways here. First, they focused almost exclusively on what counsel could have done, what more they could have done, how they could have done it better, as opposed to assessing what they actually did and whether what they did was reasonable. I think the Court of Appeals fully gave into hindsight. They looked back and said, well, it could have been, with the benefit of hindsight, this could have been done better, but that's not the standard. And then finally, the Court of Appeals also did something the appellate courts are not supposed to do. They clearly reweighed the evidence and significantly resolved conflicting evidence in a way that supported their opinion rather than deferring to the district court's findings. So
Counsel, let me maybe add to your list. But even if you get past error and you get into whether the failure was harmful, at page 13 of the Court of Appeals decision says, quote, "A finding of guilt becomes highly questionable," period, close quote. That's not the test, is it?
no, the test is whether there is a reasonable probability that the outcome would have been different. And to jump ahead here, I'm going to skip over a whole portion of my argument. I'll come back to it. But to jump ahead here, and let's say that, Dr. Mitchell was prevented from using the word depolarization or whatever it was, or you had these other experts that they brought in at the post-trial hearing and they testified. Regardless of that, the crux of this case was Mitchell said death occurred immediately. It was, this blow to the head happened, death occurred immediately. Dr. Wigren said, no, it was an older healing wound and it could not have occurred immediately. So it couldn't have been this defendant. That was the crux of the case.
There's nothing to support that the death can happen immediately under Dr. Mitchell's theory, is there? There's no statistical information. There's no learned treatises that supports his theory of depolarization. At least I don't see it anywhere, and he seems to even admit that.
The actual mechanism, I don't know, but the thing is, we all know that people can die from a sudden blow to the head. I mean, you don't need to be a pathologist to know that. So that's his opinion, and that's what he is.
Isn't that accompanied by some injury, some visible injury, or at least some
Well,
brain damage?
And that was the argument between the experts. That was the point that Dr. Wigren pulled out. That was counsel's strategy, and that's what they brought out. I mean, you're right on point. Yes, that's exactly what they did. Counsel got another forensic pathologist to come out and counter that and say, there's no way this could have happened. There would be signs of injury, there'd be brain swelling and so on. But the jury didn't believe it. So back to Justice Biles' point, no, there's no prejudice because the jury heard all that and they still rejected the argument of the defense and they went with the state's case. So there's no probability that even if you'd had this additional evidence, or if the term depolarization had been taken out, that the outcome would have been different, because the crux of the case was Mitchell said it happened immediately. Wigren said, no, it was an old healing injury. There would have been, if it would happen immediately, there couldn't have happened immediately.
There's no scientific support or any support for the theory, for the testimony that Dr. Mitchell provided for the cause of death. There's just none out there.
Mitchell provided his own experience. He cited to cases where he had worked regardless, he had some basis for it. As an expert, that's his prerogative. He provided this basis for us. Now, the other expert countered that. And the crux is that, the defense did what they were supposed to do. They found another expert. They found another forensic pathologist who said, no, Dr. Mitchell is wrong. And that's what the case came down to. So I don't know how you can fault counsel for not investigating, for not hiring experts, because they did exactly that. I think when the district court said it best. I want to go back to the district court's conclusion or a ruling on the ineffective assistance claim. The district court said, Mr. Morrison and Ms. Dersch searched for an expert, consulted with the expert, and hired the expert who directly contradicted the state's theory of the case. Now, that expert, Dr. Wigren, had access to the autopsy video, Dr. Mitchell's report, and the slides. His only disagreement with Dr. Mitchell was the timing of the injuries. That was the crux of the case. Now, in addition to looking at all the information, Dr. Mitchell had all the information that Dr. Mitchell had, Dr. Wigren also consulted a pediatric pulmonary pathologist and a pediatric neurologist. So they consulted other experts. But the court went on, attorneys are not medical experts. Okay, Mr. Morrison and Ms. Dersch hired a highly recommended forensic pathologist who believed the victim's injuries predated the time he was in the defendant's care at daycare. They relied upon their expert and his knowledge. Now, if the jury had relied upon the testimony of Dr. Wigren, the verdict would have been not guilty. So counsel did what they were supposed to do. I mean, let's you unpack that. I mean, clearly they did enough investigation.
We've read the record. I have a couple questions about what you've said that are legal issues. Number one, you said the Court of Appeals erred that in the ineffective assistance of counsel analysis, you only look at what the attorney did do you can't look at what they didn't do?
You
And
look-
what case did you cite in support of that?
Uh,
Seems like if, you know, if they didn't hire an expert at all, you're saying that that couldn't have been
Well,
ineffective assistance of
no,
counsel?
that is an act. I mean, that is what they did do as an omission, but the site for that is, I mean, the cases on this are legion. I have.
No, but
books
the
in my-
point I'm making is that you,
Right.
you would agree that an omission also counts as, I mean, you're. you see what
Yeah,
I'm
I mean,
saying?
but first, let me give you the case where, I mean, I've got one noted in my notes here. It's Williams v. Wooford, 384 F 3rd, 567, out of the Ninth Circuit, 2004. It's a. page-
587,
I'm sorry, 384 F 3rd, 567,
567. Okay.
page 616.
And then my next question is, when you're talking about how important the legal framework is under Strickland, in the prejudice prong, you not only, I mean, in showing that the outcome would have been different, but the reasonable probability, our court has defined it, is one that is sufficient to undermine the confidence in the trial's outcome. Would you agree with that?
Yeah, that's what the court has said. Yes, that is
Okay.
that is a standard. So I think, again, when you look at, you have to, when you look at what counsel did, the point is you don't use hindsight and go, well, and grade their work and say, well, they could have done more. A better attorney would have done this, whatever, because you bring it down to the bar of what would an objectively reasonable attorney do? If what they did was objectively reasonable, then that's good enough. So if not getting an expert under the facts and that were known to counsel at the time, if that was objectively reasonable, then that's okay. And in this case, of course, they did get an expert. I mean,
And
But
yeah,
go ahead.
please, Chief Justice.
Well, I was just going to say, didn't Professor Craig, though, take the position that they had deviated from the standard of care by not getting forensics, radiologists, biomedical engineers, other experts? But more importantly, I think perhaps by not filing a Daubert motion. And so it's not so much just that they would have disagreed, but it seems at least that her testimony is phrased in terms of falling below the standard, deviating from the standard. Am I correct in that interpretation? And if I am, how would you respond?
I have a lot of response to that. Number one, that is getting into the whole thing the Supreme Court said we're not supposed to do, which is getting into it's not about what another attorney would have done or what the best attorney would have done. And I think
that's different than saying
well, I think that's
what the best attorney would have done or what I would have done, but saying what a competent standard of care would be in this situation for attorney.
well, I think Ms. Craig is wrong. She is basically testifying from the point of view of hindsight after knowing how it all panned out, saying, well, this more could have been done. And basically suggesting this is what another or an additional attorney would do. And I think it's also a bit odd in a case, well, I think in all cases of ineffective assistance of counsel to have a defense expert, because expert testimony is appropriate to help the trier of fact understand a technical area, a technical subject that is beyond the trier of fact's knowledge. But last time I checked, every district judge is a lawyer, went to law school, passed the bar, practiced law. So the standard of performance of a lawyer is not beyond the trial judge's knowledge. And then you have two other lawyers in the room also telling the judge what the standard should be. And then when the defense takes another defense attorney and puts them on the stand and suddenly just makes arguments of counsel into evidence because it's coming from the witness stand, I think that's inappropriate. It's also inappropriate in this case when you want to say,
Objected to?
well, this is me making the argument to the court. I don't think it's appropriate. But Alice Craig compared to Paul Morrison, who's the real expert here? I mean, Alice Craig, she's no slouch. I mean, she's been around for about 20, 25 years, but her experience pales in comparison to Paul Morrison, who practiced for nearly 40 years. He was the district attorney, one of the largest jurisdictions in the state. He's tried more homicide cases than I have fingers and toes. He was a district attorney, the attorney general, and over a decade as a criminal defense attorney. Who's more the expert here? I would submit Paul Morrison is the expert in his opinion, and what he testified to outweighs anything that Ms. Craig would testify to. And the district court rejected Craig's arguments or her testimony by pointing out specifically that she relied on hindsight. And she relied on the assumption that a Daubert motion would have been granted, but the court said after hearing all the evidence in the post-trial motion, the court said I would not have granted a Daubert
Counsel,
motion.
can you refresh my recollection of what Mr. Morrison testified to as the rationale for the choices he made not to challenge Dr. Mitchell's testimony?
Well, one, of course, he relied on his experts, his forensic pathologist to tell him, whether, what the problems were with Dr. Mitchell's testimony. And I've got legions of case law that say, attorneys it's okay. It's effective performance to rely on your expert. That's why you hire experts. He also basically said, I didn't think that such a thing would have worked because, Dr. Mitchell has been a very long experienced coroner. This court has quoted him and mentioned him many times in many cases in Kansas. There's never been a case where Dr. Mitchell has been prevented from testifying on a Daubert or a Fry type of motion. So essentially, he didn't see the need for it. There was no point in making such a motion.
It's kind of I think it was Al Salami as our case where there was discussion about futility.
Yeah.
And but if a step that an attorney is accused or alleged to have been deficient in performance by not taking that, if taking the step would have been futile.
Yes, you're
then it's
exactly
not
right.
deficient.
Is the issue really the filing of the Daubert motion? Because the Court of Appeals, that wasn't the basis for the decision. Isn't the crux here whether or not Paul Morrison was deficient in his performance for failing to procure an expert that would address Dr. Mitchell's testimony?
That was the Court of Appeals ruling, and I argue that it was wrong because he did hire an expert.
He hired an expert, but not in the area to what Dr. Mitchell testified to at the preliminary hearing. He was on notice from the preliminary hearing. Here is what Dr. Mitchell is going to testify to. And then he gets an expert that is not going to testify to that. He's going to testify to other things. And then he says, well, the reason I didn't get an expert to testify to what Dr. Mitchell said in preliminary hearing is because my expert never told me to do that.
Dr. Mitchell is job is examining. Dr. Wigren, the expert that has been hired, is a forensic. His experience is other experts that were hired. They're actually the ones who are not qualified to speak on the subject. Dr. Mitchell pointed out. I've had injuries in the coming.
But isn't the issue the depolarization of neurons?
Yeah.
That is what Dr. Mitchell testified to at the preliminary hearing. And wouldn't a lawyer to meet the threshold of performance that's required to say, okay, I need to get an expert that is going to try to knock down this depolarization of neuron?
Lost my microphone, but talking about it enough. Here's the thing about depolarization. The Court of Appeals made a big deal about that. The counsel should have been on notice. It was some kind of red. I read that preliminary hearing. Dr. Mitchell said depolarization one time. It was not a simple part of his overall testimony was that this was a injury that caused sudden death. I don't know that word would have jumped out at anybody.
Well, not that word, but I mean, the whole point is he's trying to explain why there can be a head injury that kills a baby without any swelling in the brain or any other kind of surrounding circumstances, and that it was electronic, it was electric.
And exactly, which is why they hired Dr. Wigren, and they sent all the material to him and said, Dr. Wigren, please tell us what this is. Because as Veronica Dersh said in her testimony, she says, it wasn't intuitive to me. And so what the standard that the Court of Appeals made and what you're getting at is a standard that would be impossible for almost any attorney to meet. You're asking the attorneys to be smarter and more knowledgeable on a subject than their experts. How would they know? How would they know to look into that if the expert doesn't tell them. They
Didn't
knew
their
they need.
expert, but their expert said they never asked for my opinion on that theory.
And that's where the Court of Appeals resolved conflicting evidence because the evidence conflicted on that. Paul Morrison said he talked to him about that every time. And he said that, and I got case or citations to the record where he said that he talked to him about it every time. He always said, he said he talked about almost every time I talked to him. Record, volume 8, 167, 169, 244, volume 5, 232, and Dersh confirmed that in her testimony in 129. So
What
for
did
the Court of
Wigner-
Appeals to come to that conclusion, they necessarily had to resolve conflicting information, conflicting evidence, because what Wigren said is he just said he couldn't remember. If you read his testimony, there's a whole lot I don't recall in there.
Did the
So-
district court make a credibility finding on that?
Well, implicitly, the district court had to make its ruling. And we have to defer to the district court's ruling in that case. I've already read to
There's no
you.
express finding of fact for, as far as reweigh, because that's what you brought up on appeal is that the Court of Appeals reweighed the facts, but the district court made no finding on credibility issues, correct?
Well, there's no way that you could get these two different opinions from the district court and the Court of Appeals if the Court of Appeals did not resolve conflicting evidence in a way that supports its opinion. There's just no way. And the Court of Appeals should not have done that. It should have deferred to the district court's decision. Even if the district court didn't explicitly say, I find Mr. Morrison more credible than Mr. Wigren or whatever, that's implicit in the court's finding.
But even if you say that's true, that Paul Morrison and Veronica Dersh did bring that up over and over, they never got a response from their expert about it, right?
Actually, no, they did. They actually testified. This is again where the Court of Appeals got it wrong. He testified unequivocally. They discussed Mitchell's preliminary hearing testimony, and what he said is every time he brought it up, Dr. Wigren said, "Why are you worrying about that? This is an old injury. This is an old injury. That's all we need to focus on." And Morrison testified. He said there was absolutely zero mystery with Dr. Wigren about the testimony that Mitchell was going to give to the jury about the cause of death and its immediacy. So in
Well,
Morrison's
that's
mind,
different than-
in Morrison's mind, he had spoken to him, asked him about it. Wigren said, "Don't worry about it. It's not an issue. This was an old injury." And that was their strategy. So you're asking Morrison to somehow be smarter than Dr. Wigren, to have some kind of extra clairvoyant capability to see through these things. And, when he's relying, the expert tells him, "Don't worry about that. This is all about the age of the injury. I got this." Why would Mr. Morrison think that he needed to go beyond? There's no
Counsel.
red flag raised.
Counsel, can I ask some, what I think are really practical questions, but going to the same issue? Did the jury ever hear Dr. Wigren say, "Mitchell's full of it. He's wrong. He doesn't know what he's talking about"? And obviously I'm paraphrasing with really
Yeah.
common sense type language. Did the jury ever hear that?
Well, I mean, Dr. Wigren testified that the injury that Dr. Mitchell said was immediate or caused.
I know he
death.
gave an alternative explanation,
I-
and you've made a passionate argument that Wigren was there telling Morrison, "Mitchell's wrong, Mitchell's wrong, Mitchell's wrong." That I'm asking, did the jury ever hear Wigren say, "Mitchell doesn't know what he's talking about"?
Not in that type of
And so
language.
if
He-
you're a lawyer in this kind of a case, it doesn't seem to me to be a stretch to suggest that you have to perform adequately, to just ask your guy, just say, "Hey, you read what Mitchell testified to in the preliminary." "Yeah, I did." You heard what he said here?" "Yeah, I heard it." "What do you think of that?"
Well, and Morrison did do that. And if you read his testimony, he said that every phone call he talked to him about.
No,
it-
I'm asking about what the jury heard.
Oh,
I
what the
don't
jury heard.
care about
Oh,
what he had talked to him about in
Well,
the phone calls. I want to know, did he ask the question that would elicit the testimony from Wigren that Mitchell's testimony is, that his theory is wrong? It
No, he did
has
not.
no basis in any science that I know of, and it's completely made up.
He did not ask that question.
Okay, and isn't that brass tacks where we're at in this case? Isn't that what really matters?
No, I disagree
Okay,
because.
so help me,
Okay.
respond to that line of question.
Because they did present Dr. Wigren, who countered and contradicted Dr. Mitchell's testimony, not in the exact way that you suggested, but they did present an expert who was qualified, a forensic pathologist, who disagreed with Dr. Mitchell and said there's no way that this could have happened in the way he said it did, because it didn't happen immediately, that this was an old injury that predated the time when he was, and so they
The
did.
alternative theory, and that I agree with you as I read the record. That was the whole theory of the case.
And looking at counsel's perspective at the time, that was a objectively reasonable strategy. Now, could there have been other strategies? Sure. With the benefit of hindsight, can we look back and say maybe there was a better strategy? Maybe, but that's not the test. At the time, was that an objectively reasonable thing for counsel to do? Was that an objectively reasonable strategy? If it was, it doesn't matter if they can trot in additional experts after the fact who say different things and so on, or they can show other attorneys who have done a better job. That's not the standard. Was it objectively reasonable? That's actually a pretty low bar. And I think counsel here met it. And I am way beyond my time. So
Let me just ask you something before you sit down, because you've appeared a lot in front of us, at least in my time on the court. I've always appreciated your zealous arguments, especially in major cases, which this is. We've presided over major cases. I did as a district court judge. I just do not recall. And if you can tell me, if you can, where there's been a coroner's determination of a cause of death that is testified to, and that's the basis for the cause of death in a homicide case, that isn't right. That is just bunk. Have you ever, I don't recall that ever happening, or at least, and what do you have to say about that? Are you, as a representative of the state, what do you?
I don't recall that ever happening
stand
again.
here and say that's all right?
I'm not sure that it's bunk. I mean, that's the thing. That's why we have the arguing experts.
There's even Dr. Mitchell says there's no support for the theory.
Well, there's always no support for theory initially. Okay, he's made the theory. He's given an explanation for the cause of death. Okay, and he's a forensic pathologist. That's his prerogative to make that determination. I'm not a forensic pathologist. Now we have some other doctors saying it's not true, but that's why we have the battle of the experts. That's every court case we have experts. And quite honestly, I mean, Morrison said he did internet research, so I did too. I mean, I Googled depolarization, whatever. It's actually a thing. It is associated with traumatic brain injury. Now, whether it can cause death or so on, I don't know. That's what the forensic doctors can talk about. But from Morrison's point of view, if he did the same thing I did, he'd say, well, yeah, that looks like a valid theory. Now the doctors, I've seen many cases where you've had experts, one expert say one thing and the other expert comes in and says, no, he's full of crap, he's bunk. That happens, and those get resolved by the jury, by the finder of fact.
But isn't that what should happen here?
Well, we're not a finder of fact up here.
I know, but isn't that the whole crux of the ineffective assistance of counsel claim? Is there should have been competing expert testimony on this depolarization cause of death put in front of the jury?
There was expert testimony that was presented on the cause of death and the timing of the death, because that was counsel's strategy. They're allowed to choose an objectively reasonable strategy. Their strategy was to challenge the timing of the death, not the depolarization, whatever it is. And that's objectively reasonable. There's multiple strategies
But a
in any given
strategy
case.
has to be made after thorough investigation.
And they did that. I mean, I've been up
Looked
here.
it up on the internet.
They hired a forensic pathologist.
It is not an
That-
expert on
that-
brain
Well, I mean,
electrostation.
according to, maybe then Dr. Mitchell isn't either. But I mean, the point is, Dr. Mitchell is a forensic pathologist. He's qualified to make his conclusions. Dr. Wigren is a forensic pathologist. He's qualified to counter those. I mean, what more do you want counsel to do? I mean, how high are we going to set this
Exactly what
bar?
Counsel did in the motion for new trial at the 4-day evidentiary hearing.
They found two doctors who are not qualified to challenge a forensic
that's-
pathologist. I
That's
mean,
your
and
opinion.
again, we're looking at
But
what
that's-
other attorneys could do. That's not the standard. The standard is, what did these attorneys do, and was it objectively reasonable?
That's why I
Hiring,
asked you at the
yeah.
beginning, that I don't understand. An attorney can have deficient performance for an omission. You even said that.
but they didn't omit anything. They hired a forensic pathologist. They hired a qualified expert. It just turns out he wasn't good enough to counter Dr. Mitchell. I mean, that's, every case is like that. Every case involves experts. The jury believes one or the other. And it's not that those attorneys that lost were not ineffective or incompetent. They just lost the case. And losing the case doesn't make you defective or deficient or ineffective. Okay, they did what any reasonable attorney would do. They hired an expert, a qualified forensic pathologist to counter Dr. Mitchell. They consulted with him, as all testified many times in preparation for the trial. He gave his testimony that directly contradicted the state's case. I mean, it's not like they didn't miss the boat. It directly contradicted the state's case, but the trier of fact, the jury agreed with the state. So that's not, and we're not retrying the merits of the case here. We're looking at counsel's conduct, and that was objectively reasonable. I mean, from an objective standpoint, not a subjective standpoint, from an objective standpoint, what they did was what any competent attorney would do. Again, I'm way beyond my time, so.
Counsel, I want to, Chief Justice hates it when I do this. But you said something that I don't think you meant to say, but I need to make sure.
That's
if I'm
probably-
understanding. You said that the issue was about the time of death, and we know the time of death.
Oh, okay.
You were talking about the time of the fracture.
Yes, you're right. I mean, the time of the injury. It was the timing of the injury that led to the death. That's,
And the reason why that, I understand it, contradicts what the state's position is you can't, this injury either has to be fresh or it has to be old. And if it's old, the defendant's not guilty.
right. Dr. Mitchell's whole theory only worked if the injury was fresh. So Dr. Wiggins' testimony directly countered Dr. Mitchell's testimony. At this point, I will sit down and yield the floor to opposing counsel.
Thank you, Your Honor. The state's theory required that the injury happened right there and that the death occurred as a result of the injury that happened right there. That's this depolarization theory. Most lawyers who've done much of anything having to do with medical issues know that blows to the head cause injuries to the brain, and injuries to the brain kill people because of herniation syndrome. And that's the whole injury to the brain thing. Now,
Counsel, you've already passed my knowledge of brain injuries. But I think at its basic, I can understand the premise that I'll accept for now, that this is a brain injury. So a reasonable attorney might think, I need a brain doctor, which would be potentially a neurologist, correct?
yes, Your Honor, precisely.
But don't you agree that Mr. Morrison told his expert, Mr. Wigren, please look at this and get a neurologist if we need one? Did he do that?
Your Honor, there is a dispute in the evidence between Dr. Wigren and Mr. Morrison about their communications and what Mr. Morrison told Dr. Wigren and what Dr. Wigren said to Mr. Morrison.
But the district court found that Mr. Morrison was reasonable.
No, that's not true.
Well, okay, the
That's
district court
really-
found that he did not commit
Your Honor,
ineffective.
actually, the dispute, I'm wandering away from my microphone. The blame game between the two, between the doctor and the lawyer, was not resolved by either court.
Okay, well,
the
I want to get past the blame game.
Right, and that's what I'm trying to do.
If Mr. Morrison did in fact tell his expert witness, get a neurologist if we need one, is that enough to satisfy the effort required of an attorney to seek a neurologist if that's what is required?
Your Honor, that I don't think that hypothetical is enough. I mean, hypothetically, it is not enough. And the Court of Appeals specifically found it wasn't enough. If Mr. Morrison knows enough to ask the question, he has to get an answer to the question. If he's going to say he's going to rely upon the expert witness, he needs to get an opinion from the expert witness before he goes to trial. Now, in this particular case, Mr. Morrison said he told Dr. Wigren about this, but Dr. Wigren kept deflecting and never answering the question. Dr. Wigren says, I never answered the question because it was never asked of me. Mr. Morrison says that on the night before Dr. Wigren testified, in meeting with Dr. Wigren for the first time, Dr. Wigren told him that this depolarization theory was nonsense. The direct quote was, Dr. Mitchell must have come up with that from somewhere between his belly button and his taint, according to Mr. Morrison. Yet the next day when Dr. Wigren testified, Mr. Morrison didn't ask him about that, didn't say, well, tell us about this depolarization. But on cross-examination, the state did. And the state did ask whether a person could die from a blow to the head immediately. And Dr. Wigren testified, this is in the Court of Appeals opinion, Dr. Wigren testified, yes, but, and then tried to explain and was cut off by the prosecutor, and the court instructed Dr. Wigren that he would have the chance to give his explanation on redirect. They adjourned for the night, and yet the next morning when Mr. Morrison did the redirect, he didn't ask Dr. Wigren for his explanation. Dr. Wigren testified that his explanation would have been, had he been allowed to give it, that yes, you can immediately die from a blow to the head. If it's a crushing head injury, your brain is crushed. And he didn't get to tell that to the jury. Now, the problem with Mr. Morrison's position is that Mr. Morrison himself lamented his failure to develop this testimony, to file a Daubert motion. He testified he'd never filed a Daubert motion. I suggest, Your Honors, that Daubert at that time was 4 years old. I mean, we've had Daubert in the state since 2014. That was 2018. Mr. Morrison in his career had never filed a Daubert motion. But the district court never resolved this dispute between Morrison and Wigren, because Judge Buchhorn decided it doesn't really make any difference whether Wigren advised Morrison of this, that it's nonsense, and it is nonsense, because even if you filed the motion, I would have denied it, because I'm finding, after having conducted a Daubert hearing, because that's what Judge Buchhorn did, to deny our motion for new trial, which we filed before sentencing. We filed before the judgment was final. She decided that, that it would have been futile, because she decided that depolarization is admissible under KSA 6456B, which, Your Honor, we just think she's wrong on. I mean, and apparently so did the Court of Appeals, which gets us to our
But it
problem.
can't be ineffective assistance of counsel to file a motion that's going to get denied.
Well, that's what was her reasoning, Your Honor.
Well, and I think we've agreed with her, and that was the fight in the two different versions of the Calamini case. But here's my question. You started out by saying that there were 2 points to make. One was the date of the injury, and then cause of death from the injury, the polarization. But it seems to me that if you're faulting the defense essentially for not having an alternative theory, like, in other words, you're telling the jury, all right, this could have been a fresh injury, but still Dr. Mitchell's nuts about how that fresh injury would have caused the death. That's really what you're saying, right? Having an alternative theory. If you disagree with Wigren, if the jury disagrees with Wigren and accepts Dr. Mitchell's testimony that it's a fresh injury, right?
Your
It
Honor,
has to- I may have confused it, but
you have,
the cause of, if we know polarization isn't an issue, if it's an old injury, right?
we know that depolarization can never be an issue.
Oh, if it's an old injury, it's not a thing.
If it's an old injury, she can't have done it.
Right,
Right.
right. But I'm saying to talk about depolarization, it seems to me the defense has to concede the fresh injury.
No, you're
The
right.
jury might, if, in other words, an alternative argument, if you don't agree with Wigren and you believe Mitchell that it's a fresh injury, it still doesn't lead you to the death of this child.
Your Honor, the age of the injury is only significant because in order for Dr. Mitchell's theory to point to Mrs. Buchhorn, it has to be new. By his depolarization analysis, you get hit hard enough in the head, your brain will stop working, even though there's no injury to your brain. That's what he said. And there's no science that supports it. I forget which, it might have been Justice Wilson who
But it
talked
still has
about
to follow,
pediatric neurologists.
but counsel, it still has to follow the fresh injury. So if you're trying to, if as the defense, you're trying to focus on polarization or depolarization, it seems to me you're telling the jury it's possible that the defendant inflicted the injury. Now we're just arguing over whether that injury caused the death.
Not at all, Your Honor. Not at all. We're saying that there's no way a blow to the head causes head trauma can cause death without evidence of injury to the brain. There was no evidence of injury to the brain. The cause of death testified to by Dr. Mitchell is simply not science. It's junk science. And we brought in 2 world-class pediatric neurologists who testified to that. We asked Dr. Mitchell for his authority, his literature authority, and there is none. So what does 456B require? It requires credentials, number one. But then beyond credentials, you've got to show facts or data, and then you've got to have a methodology that you apply to the data, and then you have to show that you reliably applied the methodology to the data.
But if I'm a juror, I'm sitting here trying to figure out how a perfectly healthy young child shows up at daycare. The end of the day is dead. That's what I'm trying to figure out. And I know that if the defense expert is believed, it's an old injury and the defendant couldn't do it. But if it's a new injury, and I believe that, the defendant's on the hot seat.
Only if there's some reliable methodology that connects up anything she could have done to the death of the child.
There has to be, everybody agrees there's a fracture, right? It's a question of when it happened.
No, Your Honor, there was a hairline fracture, a non-displaced fracture at the base of the child's skull. Many of us have those. Many children have those. The testimony of all of the experts, including Dr. Mitchell, was that fracture didn't cause the death. What he said was that the blow to the head that caused the fracture induced energy into the brain that caused the instant death. That's just made up. That's like saying Gibble-me-gob caused death.
But for him to be right, that energy had to be transferred at the daycare center.
For him to be right, but there has to be a theory that recognizes that can cause death. I mean, it's Mrs. Buchhorn was convicted of murdering this child simply because she was there when the child died. As Dr. Suda Kessler, who is the chief of pediatric neurology at Children's Hospital in Philadelphia, one of the 2 or 3 top pediatric institutions in the world, testified. She said she sees a dozen or so kids every year that die that she can't give an explanation for their death.
But let's go back to the viewpoint of the attorney.
Yes, Your Honor.
And a reasonably competent attorney at that time understood there is a brain fracture that a pathologist would seemingly to be competent to say, we have a fracture and it's a fresh fracture that caused the child's death, and the child is obviously passed. How would a reasonable attorney know at that time, well, that can't possibly be true?
Your Honor, Mr. Morrison made it clear in his own testimony. He understood the significance of this depolarization thing. fact that he kept badgering Dr. Wigrin about it is evidence of that. The night before he put Wigrin on the witness stand, Wigrin told him it was nonsense. He knew this. It was his obligation to develop that, develop the answer to that, to find out. If I've tried over 100 jury trials in my career, many of them involving complicated expert testimony. And in every instance, I know not only do I have to put my own witness on the witness stand, I've got to cross-examine somebody else's witness. How do I cross-examine somebody else's witness without any bullets in my gun? The bullets in my gun are the medical literature and the treatises that deal with that issue. The very first thing any lawyer does in preparing an expert witness or into dealing with a 456B issue, and this is as Alice Craig said, the very first thing a competent lawyer does is to investigate with his own expert what those materials are. Indeed, in this case, I would suggest that the state had no basis to even ask the question of Dr. Mitchell, because 456B requires that Dr. Mitchell have had a methodology and a way of explaining how he applied the methodology to the facts of the case to reach his conclusion. He's got to know what that literature is so that he can cross-examine the other guy who comes in to testify. Our own ethical rules require that I can't stand up in front of a court or a jury and say something that I don't have a reasonable basis for believing is supported by the evidence. We have Mrs. Buchhorn convicted of murdering a baby based upon gobbledygook, because that's what depolarization is. It's gobbledygook.
Can I ask you a question that's
Yes, sure.
that's right along those lines, but I want to turn you to your condition, to your cross petition and ask.
I'm glad you are, because I've run out of time.
Yeah, if you could talk a little bit about that. And my specific question, which maybe you can answer as you talk about your cross petition, is whether or not you have case law to support your argument, as at least I understand it, that the Daubert issue is properly preserved because of the post-verdict motions.
Yes, Your Honor. I wish I could have something to give you that would directly say that. The Daubert issue was raised in two ways before the final judgment of conviction. And Judge Buchhorn denied the motion for new trial. We got in there a week or two after the verdict, and so we were in a hurry. We got this stuff going, but she conducted 4 days of Daubert hearing in which 2 pediatric neurologists. I mean, and Your Honor, I recommend you to look at their credentials.
And let me just jump in real quick and say, I don't. You can talk about the content and the merits of the hearing that happened if you want to, but what I'm specifically focused on is preservation. Regardless of what happened in the hearing, the merits.
Yes,
because the question you want to raise is, was the district court wrong? But you were prevented from even reaching the merits because the Court of Appeals said it wasn't preserved.
And let me, I am often critical of myself as an appellate lawyer because I'm too much of a trial lawyer and I don't speak appellate as well as I sometimes should. But the issue was raised to the trial court when we challenged the admissibility of the evidence to her and the sufficiency of the evidence as a basis for the new trial motion, as well as a basis that she couldn't rely upon that evidence to sentence, to impose a punishment. And she had 4 days of hearing, heard all this stuff, and everybody knew it was a Daubert hearing that she was doing. And then on the basis of her Daubert ruling, she denied the motion for new trial.
How do you get around the rule that a contemporaneous objection is required?
Because, Your Honor, the contemporaneous objection rule is intended to prevent people from raising things for the first time on appeal where the district court has not been provided the opportunity to correct the error. In this case, the district court had the opportunity to correct the error. In fact, Your Honor, there's,
So we can make what amounts to an equitable exception to the contemporaneous objection.
I think
rule.
there are exceptions. There are defined exceptions, and the people who are smarter than I am who wrote the briefs put them in our brief. But the whole idea of the rule is, you don't want to ambush the trial judge on appeal, and at the same time, you want to provide the appellate court with a fulsome record upon which to make a ruling. It's all here. And the state has not said anything that it has anything else it can add to that. And I want to add in, since you said the word equity, Mrs. Buchhorn has been at the point of the gun now for 5 years, and she spent 3 years in prison before being released after her conviction was reversed. We're going to go send it back to the district court to do what? I mean, if this court decides, or can decide and does decide, that depolarization on the facts of this case is nonsense, that it's not anything, that it's not admissible under 456B, and if 456B means anything, it means that, then why not go ahead and do that now? Why subject her to, why should we go back to the district court that's already, we think, wrongly ruled? Maybe she would change her mind. I've never had much success in going back to judges and getting them to change their minds, but I mean, maybe she would. The state insists that they're going to go back and try and do it again on depolarization. So that's, Your Honor, I argue these things probably too much as a trial lawyer and not enough as an appellate lawyer, and it just makes no sense to go back and do this all again, slog through it again. If I might say one other word, the district court did not decide this issue between Wigren and Morrison because she didn't think she needed to. She also didn't decide all these other trial issues like cross-examining with literature, putting on an expert to talk about this stuff. The Court of Appeals didn't decide the issue either. The Court of Appeals said, even if we accept Morrison's testimony, even if we believe Morrison's testimony, he's wrong because the trial lawyer who doesn't ask the expert is wrong. That would be believing Wigren. But the trial lawyer who asks the witness the question and then goes to trial without getting an answer to the question is equally wrong. And being an old guy now who's tried over 100 cases, I'm going to tell you, any trial lawyer who would ask his expert witness that critical question and go to trial without getting an answer, Alice Craig wasn't wrong about that. Thank you.
Is the court. I wrote down some notes. I hope I get to all of them. Several points I want to touch on. There was a question about a neurologist, and it's in the record that Dr. Wigren did consult a pediatric neurologist. So again, following the proper investigation, that you can't fault counsel for that because the neurologist was consulted. I want to touch on the thing about when the state asked the question of Wigren about whether or not a head injury could cause immediate death, and he said yes, but with an explanation why Mr. Morrison didn't go into that. Well, because Mr. Morrison, as he said, he wasn't sure exactly what Wigren's answer would be, and didn't know if it would help or hurt the case. So he adopted the cautious approach of not going down a path that he didn't know about. And when you look at the actual answer that Wigren gave in the post-conviction hearing, it makes perfect sense. Probably was a good thing he didn't ask the question because, and this is from page 48 of that post-trial motion, Wigren's testimony. He said, but my answer, the explanation would be, obviously, this is a very general question. And there obviously are physical things that can happen to the head, which are physical violence that can change the electroconductivity and could stop breathing, but they're not a skull fracture. I mean, he references electroconductivity. That almost seems to, suggest that maybe Mitchell knows what he's talking about depolarization and neurons and so on. And his explanation really was just, well, that's kind of a generalized question. So, I mean, yeah, there are some things that could cause immediate death, but this isn't one of them. So I don't think that's like the smoking gun that my opposing counsel tries to make it out to be. And also, as I was listening to opposing counsel make the argument what the defense expert should have said, I'm thinking to myself, well, that is what Dr. Wigren said. I mean, Dr. Wigren argued exactly what Mr. Skepnick said. He testified in summary that there's no way a person could die from a head injury without a visible injury to the brain. I mean, that's what this case was about, whether you call it depolarization or any other label you put on it. The two experts disagreed. One said it could happen immediately with no injury to the brain, with no visible injury to the brain. He said he'd seen that a couple of times in his past practice. The other forensic pathologist said, no, that couldn't happen. You would always see injury to the brain, and this is an old injury. So yeah, again, the defense expert that was hired did exactly what Mr. Skepnick said he should have done. So counsel can't be faulted for anything they did in hiring the expert.
Counsel, before your time runs out, can I ask you to address the preservation question I was asking your opposing counsel about?
Yeah, real simply, I agree with the Court of Appeals.
But why?
Yeah, the
Why
Court
are
of
they
Appeals,
right?
We actually have case law here. What I would just cite, and I'm sure you're aware of the State v. Cook, 286 can 1098 at 1109 said clearly a post-trial motion cannot substitute for the contemporaneous.
Yeah, it's
objection
not a
requirement.
contemporaneous objection. So my follow-up question is, does that mean that this kind of a ruling from a district court is effectively unreviewable?
It's unreviewable the same way that any kind of decision by the district court in a trial that's not objected to
No, but
is unreviewable.
I'm not asking about what the district court did during trial. I'm saying the district court could have said, you didn't make a contemporaneous objection, so I'm not going to do this. But when the district court actually goes ahead and says, well, okay, I'm going to entertain your objections post verdict, but pre-judgment, that's the narrow window that we're in, which strikes me as something not necessarily contemplated by the preservation statutes and rules. And the result of the Court of Appeals opinion is that it makes what the district court did here unreviewable. And that's what my concern is. And I just wanted to hear the state's perspective on that.
I think that's basically kind of what State v. Cook said, though, because you had a post-conviction motion there, and I think the court.
Well, is that what two-part question? One, is that result dictated by any statute or law? And two, is that a good result?
Well, now I'm gonna have to go back and look at Cook. I mean, I got the note in my notes, but I'm not sure. I mean, it is based on statute. The contemporaneous objection rule is in statute. So I would say at least it's based on that. I mean, that is the case law. And yeah, from my point of view, the reason we have, I made this argument before in other cases about where we try to get past the preservation rules. We have preservation rules for a reason.
But the contemporaneous objection rule doesn't directly address this situation. It doesn't address a post-trial motion that was actually based on admissibility of evidence that was actually ruled on by the district court. Why couldn't the Court of Appeals have said, well, look, we can't reverse this conviction based on the admission of this evidence, but we can review the district court's ruling on the post-trial motions?
Well, I mean, I guess I'm going to have to fall back on Cook. I mean, the Court of Appeals obviously was bound by Cook, so they couldn't. But obviously, this court could take another look at Cook and change your mind.
And well, really what I'm asking is does the state have a position on whether or not the statutes foreclose that?
Well, I'm going to say yes. Okay. But without, I would have to file supplemental briefing to really dig into that. But obviously, the court knows well my position on these preservation issues. As an appellate attorney, I like the preservation issues. I think we all need to have rules to abide by, and we follow them.
Quick summary, your view is that the statute makes this kind of a ruling by a district court unreviewable.
Yes. And then if I realize I'm out of time, if I can just, if the court will allow me to hit my last point on the Daubert
That's
issue.
fine, yes.
Okay, the Daubert issue, KSA 6456, it says that, and the case law says that an expert can testify from their experience, which Dr. Mitchell did. And, he followed, he has extensive experience. He followed accepted methods of forensic pathology and so on. That's all that's necessary to get the admission in. The case law says that Rejection of expert testimony is the exception rather than the rule. The vigorous cross-examination, presentation of contrary evidence, and so on are the traditional and appropriate means of attacking a shaky but admissible evidence. And I would just close with, an expert can testify in their own experience, and it doesn't have to have a whole lot of background in literature. And at some point, 'cause all theories start somewhere. Galileo had a theory that everybody thought was nonsense at one point in time. So maybe Dr. Mitchell knows what he's talking about. And I will close at this point and ask the court to reverse the Court of Appeals and reinstate the conviction. Thank you.
Thank you to both counsel for your arguments in this matter. The court will take the case under advisement.